Chapter 34-18.001. Purpose of the public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed rule or proposed changes to an existing rule. The commission will decide whether to make any changes in response to public comments or written materials. The commission may withdraw a rule in whole or part, or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission also may make technical changes which do not affect the substance of the rule. We will move into the rule hearing. It's now opened.
Madam Chair,
Yes, sir.
during the public comments, there was a question raised about whether I should recuse myself, and I'd like to make some comments about that.
Please go.
Thank you. First, I'd like to thank Mr. Slate for raising the concerns, and as I mentioned, I stipulated the fact that I am married to Allison Sellers, or I was this morning when I thought. And I actually am chagrined that I didn't know all the clients that she represented, so that's the embarrassing part of this whole thing, but that's also not a surprise to me because one of the ways we've stayed married for 22 years is not to talk about work at home. We're different parties, different clients sometimes, not an issue. I will affirm that she and I have had no conversations about this. I did have outreach to David Rambo at one point, but it was not about CDDs. It was about actually elected officials. He represents cities and counties. And I had reached out to Hopping Green because they are also on my board and they provided me some guidance, but they did not ask me to vote in any particular way. I think in totality, after I've considered all of this, I did disclose that my brother's a police officer, so when the sheriff testified last time, I thought that that was going to potentially sway my vote. But in totality, I don't view a conflict. I intend to participate and vote, but I will defer to the will of the chair of the body and the advice of the director.
Thank you. We are going to start with discussion by commissioners. After that, we will open up to the public for comments. Since we've had so much discussion, 2.5 hours, I would ask that if you have further comments to please be brief. After public comments, there will be comments by commission staff, and then we will close the public hearing. There will be discussion by the commissioners. For a possible vote, approving language regarding the meaning of disproportionate benefit as used in Amendment 12, and approving language prescribing the requisite intent for finding a violation of the prohibition of the amendment, which prohibits the abuse of public position in order to obtain a disproportionate benefit. I'm going to actually start with Commissioner Lesnick and just go down for general comments about the direction you feel we're heading or the thoughts you have, and we'll just go down the line. I think that's probably the easiest way to do it.
Not a surprise to any of you, I am concerned about the safe harbor language, and I do think that it does gut the amendment and makes an inference beyond what I think can be inferred, that the constitutional amendment did not intend anything new. So I am very strongly opposed and would recommend that any such language be stricken. I did listen to testimony about preserving the exemptions, and perhaps something could be crafted to provide comfort in that area and preserve those exemptions. I just think that safe harbor is far too broad and beyond the scope of what was assigned to us. I think that both alternative drafts have some great improvement in inserting the element of abuse, which was absent from the first draft. I am prone to support Senator Gates's recommendation of replacing wrongfully with knowingly and willfully, because still contained in that sentence is the notion that you've acted inconsistently with the performance of your duties. With respect to the defining public officials or public officers, or again, I think if the CRC wanted us to do that, they would have specifically asked us to do that. They did not, and so I think that's outside of our purview. So that's sort of where my thoughts are.
Do you have a preference for alternate 1 or alternate 2? That's a place to start.
I really do not. I find both of them, I think the only differentiation is the inclusion of the word class and its definition. And if that provides more comfort for folks, I'm okay with that.
Commissioner Max?
Well, I'm truly sorry that I missed the June meeting. And so I kind of come into this a little bit blind, but I would just say this, that, and I'll be very brief. I think people want to have trust and confidence in their leaders. I think that has been lost nationwide, lost a little bit in Florida. It's not hard to know what's right and what's wrong and what's good and what's bad. And my philosophy is to keep it simple. And I have watched the period of time that I have been on this commission. We do find people that violated our rules, and then I believe that we do the right thing. And to me, that's the most important thing in our life, in our government, of this commission, is just to do the right thing. I've jokingly, not really, but asked the chairman to slap somebody around a little bit, and I think we can do that publicly, and we ought to do that. So I believe we'll do what's right and implement this legislation and these rules. And so I'm for keeping it simple.
Thank you. Commissioner McManus?
Well, I agree with the two prior commissioners in principle, and specifically, I would like to see the language of intent changed to knowingly and willfully. I do not think we need the safe harbor provision. I think it could be interpreted to gut the constitutional amendment. And I'll leave it there.
Commissioner Brady?
Yeah, not being an attorney, not being a legal wordsmith, I have some lack of ability to provide specifics. I think the knowledge ruling is good at the wrongful intent. I think there's a couple of places where we did public officers and public employees, and where we suggest that we continue with the language, is there spouse, children, employer, business which he contracts, which he, and add that whole language every place it belongs. The E in both version 1 and 2, I'm not sure what that basically means. Does that mean I get a benefit and I didn't know it? It's not my fault. I think we should really look at that language and whether or not that really serves any purpose. And then the language about the safe harbors, I think if you're saying it all, it needs to be extremely narrow. And to really say, Commissioner, I've been here for going on 4 years. The commission and the commission staff and the commission attorneys and the attorney generals have been very, very good in sorting out stupid things from things that are substantive and need to be reviewed, and I trust them to be able to maintain that ability irrespective of what we do in the direction. They know what they're doing, they have a good sense of what the law is and what the intentions are, and I would not be worried about them citing an empire because we got a free soda to manage the baseball game. I mean, I think it's a level of absurdity that goes really beyond explanation.
Commissioner Byrd?
Surprisingly, I think we have a lot of similar opinions to the point. As far as the safe harbor statute goes, I wouldn't want that in either of the other commissioners that spoken. As far as changing wrongfully to knowingly and willfully, it goes along with what Commissioner Banks said, which is keep it simple. This language, knowingly and willfully, is really pretty simple. this is not a criminal statute, but we're using language that is actually traditionally in the criminal law statutes, and I can't think of more simple than knowingly and willfully. The other point that I would like to hear from our counsel, because I think it's a legal issue, is one, do we need to add definitions? Or does it suffice as is in defining? Or should we be just citing two other statutes as far as these definitions, or regurgitating the other statutes? And the involved part is, do we even have the legal authority to do so? So in regards to that, it's a legal analysis for me to have. I've heard two answers to that question, but I would like the answer from our executive director.
Yes, sir, through the chair. The amendment, if it had not given any role to the commission, would have just been effective by its own term. It would have been adjudication only, determining what it meant as we went down through the years. Of course, it did not do that. It does have rulemaking authority in it, but that's very limited. And when you look at the amendment, it says that the commission shall define by rule the term or the phrase disproportionate benefit. And then secondly, it says the commission shall by rule prescribe the requisite intent for violating prohibition about abuse of public position to obtain a disproportionate benefit. Those two things are the only things that the amendment gives substantive rulemaking authority to this commission on, in my view. The amendment does reflect that we're supposed to go under the statutory rulemaking procedures. But in terms of there's nothing in the amendment that says that we're to define public officer or public employee, or really to go definitionally anything beyond disproportionate benefit, and then the prescribing of the intent. So you don't want to go past what you have authority for, and certainly coming from this amendment, there doesn't appear to me to be authority to do anything more than define disproportionate benefit and prescribe the intent.
So if I can ask on that, so as assigned, we weren't asked to do this, and certainly your position is we don't have the authority. So the second question is, as drafted, does what is in there put someone on a specific notice about being a public figure or public authority?
Through the chair, in terms of what is a public officer, under the Code of Ethics, that is expressly defined. Now, in the Code of Ethics, there is no definition of public employee, but over the years, the Ethics Commission has construed the meaning of that term in its advisory opinion, in its complaint process, and through adjudication has come up with the meaning. Often, there are many other things in the Code of Ethics through the years that are not expressly defined. For instance, the term contractual relationship is a big part of one of the prohibitions that's in the Code of Ethics, yet in the code, that phrase is not defined. And so, and I've personally spent a lot of time on this through the years, you have to sometimes look to other substantive law and statutes to determine the meaning of a phrase if it's not defined in your particular statute or here in your particular constitutional provision. And I would think that the definition of public officer that's already in 112 is a very logical definition and would be readily usable and knowable by people in regard to this prohibition. In other parts of this amendment that deal with like the new 6-year post-employment revolving door ban that the commission doesn't have any rulemaking effort in regard to, there is a particular definition there of public officer there in that part of the amendment, which is different than the one that exists in the Code of Ethics and which doesn't have any applicability to this amendment, the part that we're dealing with here. So I think that you can say that if the framers of the amendment saw fit to put a definition of public officer into one of the prohibitions, the post-employment 6-year thing, and they didn't do it here, that they really didn't intend that there be another definition or an express definition for the purposes of what we're dealing with. But when I read the face of the amendment, I see only disproportionate benefit and only abuse, and the intent there. And in terms of what these things mean, like a crossing guard, a school umpire, people like that, deputies versus dispatchers at sheriff's offices, some of that necessarily is going to have to come out of adjudication, but it comes from a background of very logical reasoning by the commission. And Senator Gates and others have mentioned how, both during the CRC debate and today, how they trust the Ethics Commission to administer this standard. And really, that's another way of saying that we trust the commission's institutional knowledge and its expertise about things ethical. And I don't think that the Ethics Commission, in view of existing statutes and its history and just the logic of what is a public officer and a public employee, are going to come up with some definition that says that, you know, a 3-year-old in daycare that steals a lollipop is a public officer. I don't think you're going to have any absurdities coming from that. And I feel like that when you look at the way the amendment was written, if the framers had thought that they needed to specifically define public officer and public employee in our part of this amendment, I think they would have done it, because they did it somewhere else with the 6-year ban. And so I think they're trusting to the commission to logically determine, as we go forward under the provision, what that meaning is. And I don't see the need or the ability to set that forth up front in the rule.
One more question. Does anything in the rule preclude the respondent from responding that they are not a public officer or a public employee, and for the advocate or whoever to look into that, determine whether in fact that response or defense is valid?
Through the chair, certainly one of the elements to be proven in any prosecution under this constitutional standard in the future, the very first element would be, is the actor a public officer or a public employee? And just as it is with statutory provisions that have that phrase in them, you've got to show that. And it's always the respondent's ability to defend against that initial element, to say, I'm not a public officer, I'm not a public employee, I may have abused, I may have had a disproportionate benefit, but I didn't do it as a public officer or a public employee because I'm not that. I'm just a person that shovels asphalt for a subcontractor on an FDOT project. I'm not a public officer, I'm not a public employee. That is always an issue. It always is defended. The advocates are very good, as we are on the front end, commission staff, on winnowing out complaints that don't have that jurisdictional element substantively pled. So I don't think you're going to see a runaway freight train of all kinds of folks that have no traditional connection to public employment or public officership being hauled into a proceeding under this provision.
Anything else, Commissioner Booker? Commissioner Grant?
I'm trying to play catch-up. Obviously, I did not have the benefit of being on the commission in June. And just as an editorial comment, I totally agree with the spirit and intent of what this amendment does. It's long overdue. I am concerned, though, with the way it was done, but it is what it is. I wish it had come from the legislature. It would be much easier to deal with. Unfortunately, as Senator Gates said, this is another example of bypassing the legislature. The Florida Constitution now has 13,000 words. It's been amended 102 times since 1968. In most of those situations, it's been amended to do what the legislature ought to be doing. And the Constitution of Florida is not really a constitution. It's a collection of laws that bypass the legislature. But we have to deal with that. I think the problem we have is trying to define disproportionate benefit. I looked up Merriam-Webster's dictionary. It has a rather short definition. It says too great or too small when compared to something else. And now we have to define that. And I'm reminded of comments of Justice Douglas in the United States Supreme Court when they were dealing with pornography. And he said, I can't define pornography, but I know what it is when I see it. And I think the same thing is true here. It's very difficult to define a disproportionate benefit, but give me a set of circumstances, and I think I can tell you whether or not it qualifies. How do you put that into a rule? And I don't know. I read the first draft, which needed a lot of work, and staff did a very good job of coming back with the second draft. I don't think we're there yet. I think it's a vast improvement. I am concerned, as about everybody else here is, with the safe harbor provision. That really got the whole spirit and intent of the Constitution Amendment. I think it, so I look forward to the staff coming back with a third round. So hopefully, I cannot support the second draft as it's now written. But I hope I can support the third.
Commissioner?
Thank you. I think I will have to defer on all the issues related to class and legal definitions, because that is not my expertise, so I have no comments on that. I do think that it sounds like we're all in agreement that the language that fell under safe harbor, the intent was not to make it easier for people to get away with things, but really just to build on our body of experience and processes and provide certainty and clarity. And I still think that that's the process. I like what the director just said, that the fact that it was assigned to us, someone built this. I think the reality is that there are years of rulemaking and advisory opinions ahead that are going to interpret this, and the legislature is going to help in that process. So I think if there is a significant improvement, it is particularly in this space of knowingly and willingly. And I don't think any of us are trying to gut that. And I actually, in listening in June and today, don't hear two different arguments that are about the same issue. I just hear two different arguments. People want ethics and more accountability, but people also need clarity so that they can fulfill their public office. And I think that's the baby we're trying to split here, or maybe it's two different babies.
I have actually questions more than comments. I am one of the ones that am concerned about public employee, public official, actually public officer, and I say official because there's several definitions for officer and official. So, Mr. Anderson, when you say which definition are you referencing when you talk about public employer? Because there's two, and then there's one for public official that is even a little more broader. So, and I recognize the legislature hopefully will define these, but if they don't define it and you get a complaint on January 1 of 2021, I'm just concerned that I don't know what a public employee or a public officer is. So,
Yes, thank you, Chair. On that, first of all, public official, and that phrase in quotes, is a little bit different, obviously, than public officer. And public official is sort of a special term of art that really only appears in the nepotism law, 112.3135, Florida statute. The definition of public officer, which is expressly in 112, which is in 112.313, subsection 1, Florida statutes, and also the identical definition is in the voting conflict law in the Code of Ethics, which is in 112.3143, Florida statutes. That definition of public officer says, as used in this section, unless the context otherwise requires, the term, quote, public officer, end quote, includes any person elected or appointed to hold office in any agency, including any person serving on an advisory body. And then the term agency, which is in that definition, is defined in the definition section of the Code of Ethics in 112.312 subsection 2, quote, agency, end quote, means any state, regional, county, local, or municipal government entity of this state, whether executive, judicial, or legislative, any department, division, bureau, commission of authority or political subdivision of this state therein, any public school, community college, or state university, or any special district as defined in section 189.012. And then when you go to the voting conflict law, 112.3143, it starts out with, as used in this section, and then has various subparts, and it goes on to say, public officer includes any person elected or appointed to hold office in any agency, including any person serving on an advisory body. So there's a very clear and very expansive definition of public officer. It, unlike some states, in Florida, you don't have to be paid to be a public officer. An advisory body person can be very significant, so they're government. But that's very broad, I think very clear, when you couple it with the definition of agency, which refers to things governmental, not like a subcontractor laying asphalt. The term public employee is not defined in the Code of Ethics. And it's been construed in ethics decisions to speak shortly about it, basically somebody that's a W-2 form person that works for government, not an independent contractor. The notions of control of somebody that makes them an employee, which is part of that's a W-2 form, part of it is do they have their own office. For many years, before the ethics code was amended, you had a situation where you had typically county attorneys in a non-charter county. They would have a law practice, and one of their clients would be the county government or the county commission. And they didn't get a W-2 form. They were an independent contractor, so they got a Form 1099 for their compensation. The county was but one of their clients. There was nothing in the charter, it wasn't a charter county, there was no charter, there was nothing that said that the county attorney is an officer of the county. And they weren't an employee in the way that the commission construed employee. And so there was a big loophole for years that those sorts of people were not encompassed within the definition of public officer or public employee. And then the legislature passed a statute to bring those folks in. By contrast, you had city attorneys in a number of municipalities where the city charter would say the officers of the city are the city clerk, the city police chief, the mayor and members of the council, and the city attorney. In that case, the city attorney was a public officer by virtue of the charter. But the short answer there is that there is no express definition of public employee, but it has been construed to basically mean a captive person that is not otherwise brought into the Code of Ethics by some collateral statute. Now, there have been different things through the years in different statutes statutes outside the Code of Ethics where the legislature would say that so-and-so and so-and-so with this entity or that entity, they have to file financial disclosure, or they bring them in piecemeal or whatever, sometimes into the code. But I know I'm going on pretty long about that, but the public officer is very clearly defined. Public employee is pretty darn certain from many years of decisions of the Ethics Commission.
Great, thank you very much. That actually makes me feel better. And that's really all I had to say, so we're going to move into comments. Make sure I get this right. I have comments by public and commission staff. So if there are further comments by the public, if you would come forward based upon what you've heard from up here. You may have more comments. I ask you not to repeat yourself.
Do I need to restate my name?
You do, Mr. Atkins. We know who you are, but for the record.
Very good. My name's Doug Atkins from Union Beach, Florida. I just wanted to kind of bring to your attention, because this is it is a new thing, and I believe from a citizen standpoint, the expectation this should be new. There should be kind of a new standard, a higher standard, and a greater threshold. And so I think, as Senator Gates pointed out, this is where the line is in terms of ethics in the state of Florida, right here amongst you. And so I think to a great degree, a lot of the testimony that I heard this afternoon related to all these anecdotal situations that could arise, well, essentially, the legislative process will back into those. There's no doubt that the reasonableness of the legislature will seem to remedy these things through time, through the legislative process. But I think, what you've got to focus on is clearly the constitutional dynamic that you're dealing with. In terms of the definition that's housed in our Constitution, that's not going to change that much. And it's going to be the guidepost that I think that courts and others will look at. And so I think what I would encourage you to do is whatever rule, and I support the rule that was discussed on the 7th of June. I think the original one, not the modified one. But certainly I think whatever rule you do adopt, clearly you need to have principles, criteria, and standards. And secondly, I think you need to look at what is not a disproportionate benefit. And I think that relates to the jurisdiction that public official has influence over, because it's how you bear your influence that determines whether or not there's a disproportionate benefit. So with that, Madam Chair, thank you for your time. I appreciate all the work you guys have put into it, and God bless you.
Thank you, Mr. Ackert. Anyone have any questions for Mr. Ackert? Any other members of the public? Mr. Ackert?
Thank you again, Commissioners. I'll be very brief. Just on two of the concepts that were discussed here today, I would offer perhaps two suggestions, because again, I think that being able to rely on the exemptions that are in 112, as well as being able to rely on the voting conflict procedure, is very important for us to be able to give guidance to people. How do you deal with a situation that has a potential conflict, or a conflict comes up? And so what I would suggest is perhaps the commission consider language that, to the extent that you are following voting conflict procedures, or you fall within one of those exemptions, there's a presumption that that's not abuse. And I think that helps address what our thrust was, and perhaps that was inartful drafting on my part, because we drew more ire to what we were really trying to preserve, is make sure that people know how they can act. So I would just make that suggestion. And I know also that the board or the commission in the past has examples in some of their rules, and maybe that's a way to address that issue too, if you're not comfortable with the presumption approach. So, and then finally on the intent standard, the knowingly and willfully, I understand that, I get that. My concern is that if you look at that paragraph now, the concept of abuse is divorced from that paragraph completely. There's no mention of the word abuse, and this was the title of the, part of the Constitution in the intent paragraph. And so perhaps, you could consider language like knowingly and willfully acted to abuse his or her position. But I think when you take the intent standard and you don't have abuse in that standard, it's very troubling to us. So, and I appreciate everybody's time. I'm not going to take any more of it. I'd be happy to answer questions, but I have no further comments.
Thank you, Mr. Ackert. Commissioner Raymond.
Can you think of an example where we would talk about disproportionate, either more or less, as Senator Grant had said in his dictionary, where we would not have to have a class?
Okay,
Okay, so
I'm
I'm
gonna
going to
change my
have
mindset here.
a disproportionate benefit.
Right.
If I'm a single person,
Mm-hmm.
who do I have the disproportionate benefit with or to? That to have a characteristic of something being disproportionate, it has to be some kind of a distribution. That if I'm the only person in the world who drives a Lamborghini, it doesn't mean anything. So, I mean, by definition of disproportionate, don't I have to construct some kind of a class so I am able to judge whether you got more or less than everybody else did?
Yeah, I struggle with the same thing that Wayne from the Sheriff's Association struggled with on that very issue, which is why we slid whether or not there were other people affected in the class. We slid those into the 4 or 5 categories that you consider to determine whether it is a disproportionate benefit. But you may have a situation where you can't find a class, or your class is going to be really broadly defined just so you can find some people to put in there. And we start talking about comparing a superintendent's duties to a sheriff's duties, and are they in the same class or not? I see that struggle, which is why we put it down to the factors rather than make it a mandatory that you had to look at similarly situated people, because there may not be any.
Okay, but because they, again, I think by definition, to be disproportionate, somebody has to do better or worse than somebody else. And if basically there's nobody else in my class, then there's no disproportionate benefit. I'm the only person, I'm unique when that occurs. And I think part of the complication that may not exist is to make that so difficult that it becomes undefinable. I think it's fairly clear in most of our minds when somebody does better and worse than we do. That we have a good idea of what we're talking about, and we don't need 17 different classes to do that. We always can tell who's doing better than people and who's doing worse than people. And I think that when it becomes, if there is no class, then there's no disproportionable benefit. I mean, because I'm the only one that affects.
Yes.
Addressing the issue of intent, I'm looking at alternative 2 in paragraph, last paragraph, 4, paragraph 4. I'm going to read it, quote, "The requisite intent for finding a violation of the prohibition in Article 2, Section 8H2 of the Florida Constitution." So right off, we're referring to that section of the Constitution. And that section of the Constitution says, a public officer or a public employee shall not abuse. So we're talking about the intent for violations of abuse. It has to be read together with that. It's a very fundamental way to read law. You have to read it in comparing material. So it's in there already. And it goes on to say in paragraph number 4, is that the public officer or public employee acted or refrained from acting with a, let's say if we go with the new language, knowingly and willfully for the purpose of obtaining any benefit, privilege, exemption, or result from the act or omission, which is inconsistent with the proper performance of his or her public duties. You still have a problem with that?
Yeah, I think when you change the wrongful intent to just knowingly and willfully acted, and you don't reference to abuse the person's position, then yeah, I think that's going to be subject to a lot of different interpretations in terms of not having the word abuse in there. So I understand what you're saying though, in terms of you're drawing from what it says in the Constitution, you're incorporating it by reference, and so therefore it shouldn't be a concern. I'm just, when we go to counsel people, we'd much rather have abuse in there.
You wouldn't advise your client that when they're not abusing their office, they're still going to be at fault for anything they do, knowing and willfully. You would say, well, certainly this constitutional amendment prohibits abuse. Certainly, as a lawyer, you would be able to say that.
Yes, I would say the constitutional amendment does require abuse, but then when you look down to the intent standard, it really goes to knowing and willfully acting and being inconsistent. It's not saying knowing and willfully abusing your office.
Well, I just disagree with you. And it goes on to say, inconsistent with the proper performance of his or her public duties. Doesn't that also speak of abuse?
There's things that probably could be done that are inconsistent that probably don't constitute abuse. I would say that there's probably some things that you could have happen that are inconsistent. You're not going to where you should be going, but is it abuse? Maybe not, because you didn't get a benefit.
Okay. Thank you.
Thank you very much.
Any other public comments?
I wasn't wanted. I hope I can help with this question, and I'm going to speak a minute or two and then I'll quit. I'm going to reiterate the definition that was provided, and it didn't relate to somebody else. It was too large or too small in comparison to something else, which necessarily eliminates somebody. It could include somebody, but it doesn't necessarily have to be in comparison to someone else. Again, I think you could have a disproportionate benefit in relation to something that a public official did that a member of the public thought was very beneficial to the public or whatever. It might be a safari trip. I don't know. You know, it may be in relation to whatever has been done for that public official before. And it may so far exceed what you would expect from the norm that even without having to consider this in respect to anybody else, you would look at that and say, that's wrong. That's just wrong. And again, perhaps I'm arguing against myself. You know, perhaps I'm arguing against my better interests here. But it's more to the point of getting something that I think more properly reflects the analysis that should be done on a case-by-case basis. And so, again, respectfully, I think if you believe that you are required to compare the conduct of a public official to somebody else with respect to a class, I think that is incorrect. I think that's incorrect.
Thank you, Mr. Evans. Any questions for Mr. Evans? Anyone else from the public? Mr. Schaefer, would you like to comment on what you've heard today and what you've heard from the commissioners?
The only comment I'll make, and this will be very brief, is if you do decide to adopt some version of one of the alternate two drafts that Chris has presented to you, we're going to need some guidance on which, and you decide to adopt the definition of similarly situated persons, there's an either or in the draft. So there's going to need some direction on which version you want to go with, if you want to go with either of them. But there's two different versions of similarly situated persons there in the draft. Just need a little bit of direction on which version you all want to pursue.
And Mr. Anderson, I'd ask that you comment on several things, and you may have other things to comment on as well, but dealing with the willfully and knowingly and willfully intent, whether or not we should have examples in the rule, and if there's a way to preserve the exceptions, or if we need to preserve the exceptions in Chapter 112 as a safe harbor.
Right, thank you, Chair. I don't think examples in the rule are a good thing to do because I think that you tend to have some technical trouble with the Joint Administrative Procedures Committee when you start doing examples. I believe Mr. Schaefer would agree with that. Would you not, Mr. Schaefer? And in terms of preserving, you know, like things with complying with 112 or whatever, in that regard, the so-called safe harbor language, as Commissioner Lesnoff said earlier, if you're acting consistent with the proper performance of your public duty, that is, you're not acting inconsistent. You have an emergency purchase, you have a competitive bid, you have these things that are allowed. I do think that with the wrongful intent and the inconsistent language, or the knowing and willful with the inconsistent language, I think the effect of that inherently creates a situation where one will not be abusing if they're following these other standards. It's just very difficult to see how one could abuse their position if they are complying with either something in the Code of Ethics that is very specific to that dynamic, or say in the case of a special district, 1 acre, 1 vote type things. That is by legislative design going to be handled in a certain way, and they're not going to operate as a general government operates. And so inherently, those things in their proper function are going to sometimes result in things that are disproportionate in their effect or their benefit. But again, to violate the standard, there's a twofold requirement: that there be a disproportionate benefit, but that the official abuse their position in order to obtain that disproportionate benefit. And not to belabor it, but if you comply with a statutory scheme that is duly enforced on a given topic, like competitive bid or like 1 acre, 1 vote, or these things that are different, it's very difficult for me to see how that could be an abuse or an inconsistent performance with your public duties. And so you sort of inherently have, I don't think safe harbor is the best way to refer to it, you just inherently have a non-violation. You won't be able to show abuse in those contexts, either legally or factually. So I think there is merit to the argument that the safe harbor language is maybe an additional life preserver that is not needed if one already has flotation because they didn't violate the law. I think you're still going to have a difficult time convicting somebody under this or even getting a complaint started if what they're doing is following the law from other parts of the statute or the code that go to what they're doing.
What about the unwillingly and knowingly and willfully versus wrongful? Do you have a comment on that?
Well, I think knowingly by itself would not be adequate in my view to capture an intent that ought to go with abuse of public position. When you add the willfully to it, it makes it stronger. But I found willfulness to be a very problematic term and sometimes difficult to show. And from a prosecutorial standpoint, in a way, I think wrongful might be better, or an enforcement standpoint, because there is case law and there are ethics decisions that construe the term wrongfully and inconsistent with proper performance of public duty. I think it willfully is a little bit of in our context, a little bit unwieldy. I do think also, not directly on what you asked, Chair, but I think there is great virtue. There is great virtue in the fact that whatever this language is adopted here, that this standard is enshrined in the Constitution. That is nothing to be looked at as a small thing. It is very important when something becomes the organic law of the state that is beyond the reach of a given legislature. And that in and of itself is meritorious, even if there was no qualitative difference in this amendment and what it prohibits versus things that are already statutorily in the Code of Ethics. Now, if you want to compare abuse of public position in the constitutional amendment to misuse or corrupt use of public position in the existing statute, the constitutional provision is in a way narrower, because under the statute, you can misuse or corruptly use your public position in order to obtain any special seems to me to be synonymous with disproportionate, any special benefit for yourself or another. Under the constitutional provision, you can violate it only if the special benefit is for yourself or your family members or certain businesses that you have a connection to. So in a way, the statute that exists now proscribes more conduct than the constitutional amendment does, but that statute is not enshrined in the Constitution, and it could go away or it could be modified. There is great virtue in this being placed in the Constitution, no matter what you define these terms as. But I think that the wrongful intent better captures, and coupled with the inconsistency of the way that's defined, better captures what ought to be the intent than knowing and willful. Now, if you wanted to shorten that a little bit long definition that are in these alternatives about the intent, you could shorten that to that the public officer or employee acted or refrained from acting with a wrongful intent and for the purpose of obtaining a disproportionate benefit, rather than the more laborious definition of act or omission inconsistent with the proper performance of public duty. But I do think, though, that longer language has a better judicial history and a better case law basis and a better institutional knowledge in the Ethics Commission to apply than the shorter thing I just read. The reason we picked some of this language to offer to the Commission is in line with the notion that as Senator Gates mentioned, and the CRC recognize our expertise, the Commission, over many years, that we are a resource. And I don't believe that it was ever the desire in putting a good thing in the Constitution to have just a genie that has no parameters, that has no context. And if you're going to rely on the expertise of the Ethics Commission, that inherently means you're relying on what they have said about things through the years that are very similar. And that body of law is good, and we've had some good convictions under these existing statutes. And we can have some good convictions, if you will, or findings under this constitutional provision. Well, we always will know that because this is in the Constitution, it will always be a tool in the toolbox, and it will take a master blacksmith to get it out of that toolbox, unlike a statute.
Any commissioners have any questions for staff? Come on.
Mr. Schaefer has asked us a good question, and we have three options actually in front of us. No language discussing class or similarly situated, one that is discussing similarly situated, and one that includes class. And I honestly do not understand enough of that. So with my colleagues that are attorneys, or maybe the director or Mr. Schaefer, kind of help us define which of those choices might be, or what's the distinction, if there is any?
If I might,
Small
Yes,
word.
please,
please.
Chair. Right, again, you know, class is the only thing that's different in that alternative one versus alternative two. And, I think the comments we got from the Joint Administrative Procedures Committee earlier maybe went to class and went to similarly situated. So if you, take out the word class, then you kind of got rid of one of the things that, not that they objected, we didn't get an objection from the Joint Administrative Procedures Committee, we just had a suggestion. But, I don't know if class adds a whole lot to similarly situated, because class inherently kind of goes to the notion of who's where and how many are there, which is almost kind of synonymous, I think, in a way with similarly situated. Ray, would you think that's a fair statement?
Yes, I would.
And so the rule is a little fatter, and Commissioner May not quite as lean if you leave the class word in there. The one that doesn't have class is probably more straightforward and simpler to administer. I don't know what you really lose if you get rid of class. I think you still have the concept of disproportionate in relation to others, and that kind of thing. Although I would say, in regard to, and if I'm wrong, Commissioner Brady, on what you said, tell me, but I think though that if you had just a class of one or just one person affected, that doesn't mean that you don't have a disproportionate benefit. That might be the best case for a disproportionate benefit when there's only one person affected, if it was done through an abusive activity or omission.
Perhaps I assume so. I think that usually when we talk about disproportionate, we really talk about somebody that's better than somebody else, or somebody that's worse than somebody else. And we don't tend to think of people having a disproportionate benefit unless it's really in terms of a community standard of some kind. So I mean, I think at least when I look at this, you know, I'm an attorney, you know, you kind of get the sense what we're really looking for is somebody who really takes advantage of everybody and walks away with a pot of gold. I mean, and that's the sense I get, that somebody is using their influence to get something that nobody else has, rather than to say, you know, well, they got something. But disproportionate really, for me, tends to mean somebody did better than everybody else. If you just did it, then you just did it and you used the other parts of the code. This, I assume, is trying to put another standard that says, you know, there are people who steal, and then there are people who steal from everybody. And then that's how I tend to think of the disproportionate more than the idea that, and I do understand the idea that in all of our perceptions, some people do better than others, whether or not they really do. But that, to me, it's again, you need to kind of make that judgment in terms of other people in the group. So if a county commissioner and I vote to do something, and everybody's better off because I vote to do something, but I'm much better off than everybody else, and it was done abusively, then that's a disproportionate benefit. Yeah, the attorney law wordsmiths do things that I've always understand.
Thank you, Dr. White, and the Chair.
Yes.
Just briefly on that, obviously, in society, in the general reaction of the public, you just call it haves or have-nots, people that are better off or whatever. There's always going to be things that exist. There's never going to be a complete socialistic equal result for everybody every day in this state or this country. And there are going to be winners and losers. There are going to be people that benefit more from the actions of the legislature or the county government or the city government or whomever there's always gonna be policy choices. And I know that Senator Gates and others never intended to get in the way of a valid, non-abusive policy choice. There are things like that that are every day in front of government, and there's always gonna be winners and losers. I think what this amendment is looking at is when you're getting something that is disproportionate, whatever we decide that is here, but primarily because they abused their position, not because they acted in a bicameral legislative system, where you have the courts, you have the executive, you have all these avenues for seeking things and getting relief, and there's things that can be done privately, but there's never going to be an exact equality of result. And I know this is not what this is about. It's about somebody doing something wrong or possibly willfully and knowingly inconsistent with the proper performance of their public duty, out of line to get something that they otherwise wouldn't have got.
I have another question. Sorry, go ahead, Commissioner Love.
I just want to clarify, I think initially I heard from, I believe it was Senator Gates, maybe Mr. Hayes, that wrongfully is a no-no word in certain legal spheres. It's ambiguous, it's problematic. You are saying that in our body of opinions and history, that wrongfully is well-defined, understood, and that's a term that doesn't give, that shouldn't give us any agitation.
If I might, through the
Yes,
chair.
yes.
And of course, what our history of wrongfully has come from is the definition of corruptly, that embodies both the word, the wrongful intent, and inconsistent with the proper performance of public duty. And it is a somewhat cumbersome definition. But the case law that has interpreted that, the leading case, one of the leading cases on that would be Blackburn versus State Commission on Ethics from this court here in it wasn't here, it was down at law school in 1991. And it basically, one of the things it says is that if what you're doing has a valid public purpose, that you're not going to be acting wrongfully and inconsistent with the proper performance of your public duty. And it is somewhat like, I believe Commissioner Grant said, that the U.S. Supreme Court said, I kind of know it when I see it. Now, of course, rulemaking is to give people notice up front, and that's why we're engaged in this. But some things inherently have to be adjudicated. And, when you get bad facts or real nasty facts, it's an easier case to prosecute. But I just think that you've got to have some sort of mens rea, that mental state that encompasses some sort of wrongfulness, which I think is synonymous with abuse, because we don't want to get down to mere use, or that is effective use of your office for your constituency, or effective use of your office for pluralistic interest groups that you represent, that you're identified with, that's not going to be it. It's got to be something dirty, and it's got to be something rather incident to buy over.
My second question is, based on schedule, I'm getting the impression that if we don't adopt something today, we will not meet our constitutional deadline.
Let me, if I might defer to Mr. Schaefer on that procedure, then on that timing, if you would, Greg.
There's two deadlines here. The first deadline is the one given in the constitutional amendment of October 1st. If we see this again on September 13th, I think is our next meeting, let me think about this. If we publish a notice, if the commission waits to adopt final language until then, I'm going to have to publish a notice of change after that meeting. And then I'll have to wait 21 days before I will be able to submit the Department of State, which would put us into early October. I believe that's going to take us past the October 1st deadline. In terms of the strict deadline in the Administrative Procedures Act, every time we notice another public hearing and hold it, they extend the deadline of the Administrative Procedures Act for an additional 45 days. So the second deadline I'm talking about here is under the Administrative Procedure Act. I'm not as worried about that. I'm just worried about us meeting that October 1st deadline, because if we wait to adopt any language until then, and I have to publish a notice of change the Monday after our September 13th meeting, I'll have to wait 3 weeks then to submit it to
Chair.
Yes, sir.
Gray, if you, Mr. Schaefer, if you would, follow on what you just said there. I mean, we view it that there needs to be some concrete language coming out of this meeting today to deal with that deadline. And so, Mr. Schaefer, if the concrete language is adopted today, there are two possibilities I think you've envisioned in terms of what would happen with that. And we were talking about that yesterday. What would you just briefly tell us what that is?
Sure, and I shared this in my presentation at the very beginning of the workshop. If you adopt a version of the rule today that has substantive changes from what was presented to you all in June, you could technically vote on that today, and you would not have to see it again at the September meeting. But if that's the case, then I'm going to have to prepare that notice of change, submit it to JAPSI. JAPSI may or may not have feedback, and you wouldn't be able to view that. You wouldn't be doing that feedback then unless you see this again in September. Option 2 is for me after today to publish a notice of change if there are substantive changes, give it to JAPSI, and I would prepare a circ as well to give to JAPSI. And then if you all wanted to see it, take one last vote on it in September. At that point, you'd be able to see any feedback that JAPSI would have provided. At that point, because you've just been taking the final vote and everything would have been properly noticed, the notice of change, I could go ahead and file it at the Department of State 2 weeks later. After the final hearing, I would wait 2 weeks before we submit the rule packet for adoption. So the long and short of it is that you could vote on it today and be done with it, but you wouldn't be able to see JAPSI's feedback. If you want to see JAPSI's feedback and maybe read over that search statement that I'm going to be preparing, you might want to take a vote today to let me go ahead and prepare those statements based on language you've arrived at, with the understanding that you'll take a final vote on it, considering any feedback from JAPSI in September.
If I might through the chair.
Yes, sir.
Mr. Schaefer, on that, both of those scenarios, there would not be the opportunity, if concrete language is adopted today, under both of those procedural scenarios, there would not be the ability to change any substantive language in September that's adopted today, right? The language today is the concrete language.
Through the chair, that is correct. I really need to make our deadlines, I need concrete language today. And when I say that in September you consider feedback from JAPSI, we'd just be crossing our fingers and any feedback would just be technical, and it wouldn't require us to file yet another notice of change.
Given that, I'm hearing that we need to adopt language today to be time. If that's the case, after discussion.
I have a question. Mr. Anderson, I am still struggling with this disproportionate benefit, and I tend to think that disproportionate benefit doesn't necessarily have to be compared. I think to what it can be compared to is much broader than to another sheriff, another school superintendent. I think it can be compared to even the general public. I don't know that we have to compare it to someone. That's why I like the language proposed in the one from the group regarding inconsistent with the proper performance of his or her public duties, and then putting similarly situated persons as a criteria to look at under your subsection 3, the degree to which the benefit, privilege, exemption, or result is not available to similarly situated persons. So that's another criteria in the totality of circumstances. Does that work within your framework, or do you think that is a bad idea?
Just keep it on.
That would be,
So through the chair, essentially what that would do is it would move it from the definitional section down into the one of the several criteria. I think, Mr. Schaefer, we maybe had experimented with that orally through the months about whether something should be a separate definition, or what do you think that would do if that was moved there onto the criteria, into the criteria rather than being up above in a definition?
actually, you still have the, and I wasn't unclear. So you would still have definition 2A for the purpose of disproportionate benefit means, but you would strike not available to similarly situated persons and insert inconsistent with the proper performance of his or her public duties.
Okay.
And then similarly situated, could still say in the definition that you would have a 3F, which I'm just putting to the degree to which the benefit is not available to similarly situated persons. I don't know if that, because again, I don't know that it always has to be to a similarly situated person, and that class may be difficult to define, and I like the concept of it being a criteria to consider. So I don't know how that works within the framework you can deal with. Either Mr. Schaefer or Mr. Anderson.
Right, I see great thinking on that. Ray, you have a thought on that?
My first thought, Chair, and I'm just turning this over in my mind, if we were to say that disproportionate benefit means a benefit, privilege, exemption, or result inconsistent with the proper performance of your public duties, that would mean that any benefit, privilege, exemption, or result that's inconsistent with proper performance of one's public duties of any degree would constitute a disproportionate benefit. That would be how I would read it. And again, disproportionate to me means that you are, that it's out of proportion with the norm, that it's something greater than what others are going to receive. So I'm just trying to turn that over, because I think if we take your suggestion, it's going to mean that any benefit, privilege, exemption, or result, however great, however small, is going to constitute a disproportionate benefit.
But it still has to be an abuse. That's why, because I could vote for something as a county commission, and I could get a big benefit, but it might not be an abuse. And it would be something that I wouldn't get if I hadn't voted for it, therefore it'd be disproportionate. I'm just, because the similarly situated persons I'm struggling with, based upon what I've heard here today.
If I might, through the chair. On that, if you didn't have the definition of similarly situated persons in the rule, when you got to a given complaint, a given adjudication, the reality of the facts in that situation as to who was similarly situated or not would bear on the outcome. And it's hard to put in a rule the full panoply of possibilities that could exist if you start talking about sheriffs versus clerks versus county commissioners versus big county sheriffs versus sheriffs that are anti-hunters versus those that like to go to Africa. You know, if you can't encapsulate all that up front. If one were to jettison the term similarly situated persons altogether, that could be a possibility that might make the thing more definite. Do you have any thoughts on that, Mr. Schaefer?
Read to me, through the chair, I'm just reading me what the rule would look like then, just so I make sure I'm tracking with exactly what the meaning of the
If you look at the July 19th letter, I mean, it's their C. I mean, excuse me, their 3. As we heard, putting similarly situated could be a criteria to consider